Honor, we asked that the court address this case because it was a reset jail jury, and the case had not been addressed. So we asked to have it brought back to address it.
It was reset jail jury from SAP before?
Correct. In January of 2025. Which is why which was why we brought it back.
And it didn't make it to the division? I'm just confused what happened.
It went to the division. It did go to the division. The defendant had plea and arraignment February 19th of 2025.
And it's back here.
Right. The arraignment was before Judge Mather. And the case is in Judge Mather's courtroom.
Okay. I'm just confused why it's back to me, Ms. Falk. Maybe help me here.
So the defendant has now been in jail for, let's see, just to pull this up for Your Honor.
I got it, 121 days at least.
That is correct, on a criminal trespass.
Okay.
And the state just wanted to give the defendant an opportunity, if he wished to enter a plea, to enter one.
I doubt that's going to happen. All right, Mr. Harris, your case is 24 CR 008301G. You're charged for criminal trespass in this case. I understand that you have declined the services of the Public Defender's Office. It's my recommendation that you allow them to assist you today. Do you still wish to represent yourself?
Yes, ma'am.
All right. I'm going to allow Ms. Falk to put the offer to resolve this case onto the record today to see if you wish to plead guilty. So we're going to go forward with that. But first, do you do fully understand your rights today, including the right to an attorney?
Yes, ma'am.
Okay. All right, Ms. Falk, the offer in this case is?
The offer is time served, Your Honor, which would release him effective today. The state's recommendation is based on the fact that the defendant has been in custody for 121 days. This incident happened December 25th of 2024 at the Greyhound bus station at 232 Forsyth Street Southwest in Atlanta. The defendant officers were called out to that location because the security guard had asked the defendant to leave several times. He refused. He stated he was a sovereign citizen, did not need to leave, and the officers, after asking several times, finally took him into custody.
Understood. Okay, so Mr. Howard, do you wish to take a plea today to resolve the case? The state is essentially offering to close the case based upon the time you served in the Fulton County Jail. However, they are asking you to plead guilty, and there were certain questions and representations you'd have to make to do so. How do you wish to resolve your case today?
I'll plead guilty.
You would like to plead guilty?
Yeah. It wouldn't matter on either way, correct? If I did not plead guilty, like the first trial.
This isn't just some confused defendant who wandered into court. This is what people online call the sovereign citizen king. A man who genuinely believes the laws of the United States don't apply to him, that judges have no authority, and that somehow he personally controls property, jurisdiction, and even government power just by saying the right words. Sounds wild, right? But today you're about to see what happens when fantasy collides with real-world consequences. This case starts simple: criminal trespass at a Greyhound bus station, but it quickly turns into something much bigger. We've got a defendant who refuses lawyers, claims royal status, talks about gold and silver currency, and insists police can't touch him because he's sovereign. Meanwhile, the court is offering him the easiest deal imaginable: plead guilty, time served, walk out today. No trial. No extra jail. Just freedom. But here's the twist: people like this don't just fight the law. They fight reality itself. They talk in circles, contradict themselves, and sabotage their own freedom. And as you'll see, even when the judge hands him the exit door, he manages to trip over it hard. So buckle up, because this isn't just a courtroom hearing, it's a masterclass in how not to handle your own case.
Okay, I'm going to ask you some questions. I'm going to place you under oath. Please raise your right hand. Do you affirm that the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right. I'm going to have to ask you some additional questions because you're representing yourself. Again, you are declining the services of the Public Defender's Office. Do you wish to have their assistance? I recommend that you take it.
I mean, I have paperwork showing, proving my sovereignty, ma'am. But I mean, if it doesn't go towards the jurisdiction, I'll just, go with the best option.
Okay, so the answer is no. You don't want them to help you.
So, ma'am.
Okay. Do you agree that the state has the proper defendant, being you in this case?
Yes, ma'am.
Do you agree that this took place in Fulton County?
Yes, ma'am.
And do you stipulate or, in a sense, agree that the facts that's just put on the record are what happened that day? You may disagree slightly, but for the purposes of this plea, do you agree that that's what happened?
Yes, ma'am. And I had for that day I had a compensation on courtesy transportation, not by just the officer that didn't arrest me. It was another officer that took me in and said he was going to pay for my bus ticket, but also the bus driver for helping out one of the people on the bus, giving up my seat and everything of that nature.
Okay. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding today?
No, ma'am. I don't smoke or drink. If I'm
Okay.
out, I drink wine, but that's it.
All right. Did anyone promise you anything in exchange for taking a plea?
No, not at all.
Okay. And you don't feel forced to take a plea today, do you?
No, I'm not forced at all.
Okay. And you, again, are declining the services of an attorney, even though you understand that you have a right to an attorney at this proceeding.
Yep.
And you understand that you're giving up your right to trial as it pertains to this matter?
Yep. There ain't no point in going to trial for criminal trespassing if I already time served. So,
Okay. And you're giving up your right to have the state prove this charge against you beyond a reasonable doubt?
No, ma'am. I ain't giving up no rights.
Oh, if you would have to give up your right to take a plea. If you don't want to take a plea and we proceed to trial, essentially I'm asking if you still want a trial. Do you still want a trial on this?
No, go ahead. I'm fine with that. I'll do trial.
Okay. And you understand that taking a guilty plea may affect other aspects of your life, such as an open case if you have one, any probation issues, anything of that nature?
No, ma'am.
You don't understand that?
No, I understand it. I'm agreeing with you.
Okay. All right. As to the charge of criminal trespass, Mr. Harris, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional, Ms. Falk?
No, Your Honor.
All right. Essentially, the time you've served in the Fulton County Jail should close your case. All right. Best of luck to you, Mr. Harris.
I'm saying I get all my information.
Okay. And will somebody at the jail be able to help him sign the paperwork? I'm not sure who, but it was somebody, because he won't be able to get out if we don't.
Right here is where things already start getting interesting. The judge isn't hostile. She isn't rushed. She's actually trying to help this man. He's been locked up 121 days over a simple criminal trespass. Not a violent crime, not a felony spree, just refusing to leave a property after being told to go. Most defendants would be desperate for legal help at this point. But instead, Mr. Harris doubles down and says, "Yes, ma'am, I'll represent myself." Now let me explain why that's dangerous. Courtrooms are not debate clubs. They run on procedure, rules of evidence, and legal language. When you represent yourself, you are held to the same standard as a trained attorney. No shortcuts. No excuses. No, I didn't know. And sovereign citizens almost always think magic words can override that system. They believe jurisdiction disappears if they reject it. But the court doesn't work that way. Jurisdiction isn't optional. It's automatic the moment you're charged. So while the judge politely offers help, he's already stepping into the trap of his own beliefs. And what's crazy is, the state is about to hand him freedom on a silver platter. All he has to do is not sabotage himself.
Who do we have in courtroom 2?
Position 9, Mr. Harris.
Okay. And this is your case, Mr. Chitayo?
Yes, sir.
Mr. Harris. No, this isn't my case, Your Honor.
Okay.
He wanted to go pro se. Oh, that's right. Yes. Yes, he wants to go pro se.
okay. Good afternoon, Mr. Harris. You have a right to remain silent. You have a right to have an attorney represent you at these proceedings. It's my understanding that although we have offered you the assistance of a public defender this afternoon, you wish to proceed without their assistance. Is that the case?
Yes, sir. I'm a royal and a sovereign citizen.
Okay. Mr. Harris, you've been charged in case 25 CR 002224Y with criminal trespass. Is there a history, Mr. Howard?
7, resident of Tampa, history out of Florida, Pennsylvania, and Maryland. 2024 theft, 2024 trespass arrest, 2024 probation, 2023 DUI. He got time served last week in SAP and was released Friday. So he's back.
Okay, Ms. Melchizedek?
Um, yes, Your Honor. This incident is from yesterday, April 28th. The location is the Greyhound bus station located at 232 Forsyth Street Southwest, Atlanta, Georgia. Officers spoke with two Greyhound security officers who explained that the defendant was criminally trespassing and refusing to leave the bus terminal. The officer approached the defendant, who the officer recognized from a similar interaction that he had with him on April 27th, 2025. The defendant was sitting in a seat of the Greyhound bus terminal, refusing to get up. The officer asked him what was going on. The defendant stated that he was about to ride the bus to go home. The officer explained to the defendant that he had already been criminally trespassed from this location on December 25th, 2024. The defendant told the officer that he's a royal and sovereign citizen, and therefore he cannot be trespassed from anywhere. The defendant was arrested. Your Honor, the and he also pled to criminal trespass on April 24th, 2025, during the SAP calendar. In that case, is 24 CR 008301G. It was also from the same location. Your Honor, the state's recommendation is a $1,000 surety bond. Stay away from Greyhound bus station at 232 Forsyth Street Southwest, Atlanta. Social service visit to determine if a VHET is needed. No alcohol, drugs, or weapons while on bond, and that is all for the state.
Y'all can say anything, Merle?
Give me a second. Hold on.
All right, no problem.
Yes, Mr. Harris, you do have a right to remain silent. Anything you say can be used against you. With that said, what would you like to tell the court?
Well, as a royal, my duties here was to work directly with the NRA, and I have a corporation that I deal with, which is a big step being that I own under my sovereignty name, which is Tyrone Harris. I have cybersecurity and security that's implemented in throughout the states that I have to come by and also deal with. I have eminent domain, which is any private property that's in use. I can use it for public use for any type of business.
This moment right here is pure irony. The state just offered him time served. That means no more jail, no drawn-out trial, no extra punishment. After 4 months behind bars, he could literally walk out the same day. And instead of just saying yes, he starts talking about crayons and justice scales like he's still in some imaginary pretrial chess match. Here's what most people don't realize. Pleading guilty isn't about admitting moral failure. It's about closing the case legally. Courts care about efficiency. They're offering him a deal because they already punished him enough. But sovereign-style defendants confuse ideology with outcomes. They want to win arguments instead of winning freedom. You can hear it in his voice. It wouldn't matter either way. That's a dangerous sentence in court. Because in real life, guilty and not guilty are complete opposites. One sends you home. The other risks keeping you locked up. The judge even pauses to correct him, basically saying, "No sir, this absolutely matters." And that's the theme of today. A man who thinks words control reality, meeting a system where reality controls the words.
Non-monetary conditions in the state of Pennsylvania. That's any cash, any currency of the U.S. dollar doesn't apply to me because the currency that I use is gold and silver that's already implemented in the banking system, the state treasury fund of that nature. And I have sovereign immunity also, so all cash charges are charged back, just like my case that I just passed before. I served 4 months in about a week and 2 weeks, and I already pled not guilty for the first pretrial. Because I had a proof of a ticket and a proof of one of the officers saying they was going to compensate a ticket for me to go back to Tampa, Florida to deal with business. And also that's
Mr. Harris, I think I understand. So thank you, sir. I appreciate that. As for this matter today, it's going to be $1,000 good bond, stay away from the Greyhound bus station, and no drugs, alcohol, or weapons while out on bond. You'll have the opportunity to present your case at your next hearing, sir. Good luck to you.
Is there any way I can get an expedited transportation back to Tampa, Florida? If I can't use a Greyhound bus station to go back, even though I had travels to do that,
What I would suggest to you, Mr. Harris, is that for your next hearing, that you might want to consider letting the public defender speak on your behalf and help you get some of those arrangements. That might be a possibility if you can have someone, if you can get those arrangements made. So, but that's up to you.
How about you?
Yes, position 13, Tyrone Harris, and he's going pro se too.
This is State versus Tyrone Harris, case number 25 CR 002224Y. Mr. Harris is accused of criminal trespass from April 28th, 2025. Mr. Harris, you have the right to remain silent. Anything you say about the facts of your case during the course of this proceeding, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one would be appointed to represent you, and you'll be represented by an individual who understands the criminal rules, procedures, and the law. However, if you choose to waive your right to be represented by counsel and choose to represent yourself, then you are responsible for understanding the rules, law regarding the crime of which you've been charged, and that you are responsible for any legal decision and its impact upon your circumstances, including your freedom, your job, any professional licenses you may have, or any other open cases you have. I understand that you want to represent yourself. Is that correct?
Yes, ma'am.
Do you understand the consequences of representing yourself?
No.
I'm sorry, do you understand?
Yes, ma'am.
All right. You had your first appearance on April 29th of this year, and you received a surety bond of $1,000. Good bond with requirement to stay away from the Greyhound bus station at 232 Forsyth Street. How would you like to proceed with your case today? Are you entering a plea of not guilty and requesting a trial, or have you considered a plea offer and want to enter a plea in exchange for a recommended sentence?
I'm trying to get what you're trying to say, because also I had a criminal trespass. I spent 4.5 months before that last criminal trespass I just had, and I already had a surety / guarantee bond, which I have now as a royal.
Listen closely to how the judge handles him here. She's not mocking him. She's guiding him step by step. Are you sober? Were you promised anything? Do you understand your rights? That's not intimidation, that's protection. Courts do this to make sure pleas can't be appealed later. And every time she gives him a legal life raft, he responds with stories about bus tickets, courtesy transportation, and random side narratives that don't actually matter to the charge. This is classic sovereign citizen behavior. Instead of answering the legal question, they tell personal mythology. They think context replaces compliance. But courts don't operate on vibes, they operate on facts. Were you trespassing? Yes. Were you told to leave? Yes. Did you refuse? Yes. Everything else is noise. And here's the part people miss. The judge is actually saving him from himself. She keeps clarifying, repeating, slowing it down, because once that guilty plea is entered, it sticks. She's making sure he can't later say, I didn't understand. But ironically, he still doesn't truly understand what freedom costs. Accountability. Clip 4. And there it is, the mask slips. The narrator even says it out loud. When sovereign citizens want out of jail, suddenly jurisdiction becomes very real. It's amazing how fast fantasy collapses when the cell door won't open. All those claims about being royal, immune, untouchable, gone the moment paperwork needs signing. But the wildest part? He gets released and reoffends in 3 days.
You are booked in on criminal trespass from a December 25th, 2024 incident. You were booked into the Fulton County Jail on Christmas Day of last year, and you were released on April 25th, 2025. 3 days after being released from Fulton County Jail, you have been arrested and charged again with a new criminal trespass charge. So if you're asking me to give you a signature bond, that's denied. If you're asking me to dismiss the charge, that is denied. So again, I'm asking you, would you like to plead not guilty and have a trial, or would you like to consider a plea offer from the prosecutor?
All right, what's the plea? What's the plea?
Mr. Scirocco, what is the plea offer?
It is 12 months to serve 22 days, credit for time served, 11 days. This is for position 13, correct, Judge?
Correct.
That is from April 28th, 2025 to present, for him to complete, behavioral health evaluation and any recommended treatment, and for him to stay away from the Greyhound bus station located at 232, Forsyth Street in Atlanta.
All right, Mr. Harris, you'll be placed on probation for 12 months.
I'm not from Atlanta. I'm a sovereign citizen. I'm a royal sovereign. I got paperwork.
Well, even if you're a sovereign citizen or a citizen of the moon, you'll still be placed on probation.
Understandable. Well, if I have non-monetary conditions, which I use the state treasury fund to pay for everything, what does that entail?
I don't understand the question.
I have non-monetary conditions in a state that I've never been into. What does that entail for other jurisdictions that follows up the Commonwealth state?
I don't understand the question, so I don't know how to answer it. The only question I want answered is whether you want to have a trial or whether you want to consider this plea offer. All right, we will return to your case. You may have a seat and ponder the question. Next case, please. Mr. Harris, have you reviewed the paperwork for your plea?
I haven't received paperwork, but I plead not guilty.
You have not received it?
No, ma'am.
Okay.
Last time either.
Your Honor,
He never said he was taking a
plea. That's a sovereign citizen.
Oh, okay. So, that's right. Sorry, Mr. Harris. I left you with the last question was whether you want to consider the plea offer or whether you like to plead not guilty and have a trial. So have you made a decision?
No, I plead not guilty.
Okay.
I've never seen paperwork, so.
No, you won't see paperwork. I thought you were considering a plea. All right.
Yes, ma'am. The last 3 trials I haven't received paperwork.
Okay. So, Tyrone Harris, case number 25 CR 002224Y is accused of criminal trespass from an incident date of April 28th, 2025 in Fulton County, Georgia. The criminal trespass is a misdemeanor offense. Mr. Harris, would you like me to read the accusation or would you like to waive a reading of the accusation?
You can do what you do, ma'am. I appreciate you.
That doesn't answer. Do you want me to read the formal accusation or do you waive a reading of the accusation?
You can read it for me.
Repeat?
I said you can read it for me.
This accusation submitted by the Solicitor General of Fulton County was filed on April 29th, 2025. And with respect to the accusation, the Solicitor General of Fulton County, Keith E. Gamage, does accuse Tyrone Harris with the offense of criminal trespass in that on or about April 28th, 2025, in Fulton County, Georgia, the accused did knowingly and without authority enter upon the land of Greyhound bus station located at 232 Forsyth Street in Southwest Atlanta after receiving prior to such entry notice that such entry is forbidden by the owner and authorized representative of the owner on December 25th, 2024 in violation of Georgia law section 16-7-21. Upon this accusation, you have decided to enter a not guilty plea. Upon your entry of such a plea, the case will be reset for a trial. You have the option of either considering a jury trial or a bench trial. At the time of the trial, the prosecutor has the complete burden to prove the charge against you beyond a reasonable doubt. If the prosecution does prevail, and overcome your legal presumption of innocence, you could be convicted of this offense and face a possible penalty of up to 1 year in prison and/or up to $1,000 fine. Given this information, how do you plead?
I plead no contest, not guilty.